chosen because there was a workbook that was distributed, and it had particular questions that people were encouraged to answer. And they did, of course. So the agenda is somewhat set by the choices that are made in preparing the discussion document, or discussion guide, I think they call it. Nonetheless, we dealt with a number of things like the idea of the business product or the work product, which in fact is reflected here in the legislation. Some clarifications on behalf of the Privacy Commissioner, which would allow him to not have to do a complete investigation before he could, he could refuse to investigate something, which you need to allow that kind of administrative discretion in some cases, and we have to believe we've hired good people who have good legislation to work with to help them make those decisions. We needed to deal with the Patriot Act in the U.S. and the fact that any time a multinational corporation received personal information from Canadians, or from Albertans more specifically, it went into their parent company in the States, and they could then use that information the way they wanted to, not subject to our laws. So there's a requirement now that if you are collecting personal information and you know that it could end up in a U.S. multinational office, the requirement is that the Alberta recipient of the personal information takes the steps to make sure that it's not passed on, or the information that the individual knows that it will be passed on, whichever is appropriate there. In fact, the one area that seems not to have come out at all in any way, shape, or form in the Amending Act was the bringing the not-for-profit, voluntary, charitable sector completely under the scope of PIPA. And I remember we had a number of discussions about this because they were half in and half out. If they had a commercial product or a commercial venture, the NGO sector, let me call it that as a shorter way, would get captured under PIPA because it was the part of it that operated as a commercial venture would be covered and would have to adhere to the regulations. But the rest of the organization may not. So, you could have a church that ran a brunch on Sundays in its basement and charged money for it. Well, that part of it and personal information around that would be included, but the rest of the activities would not. And we were very concerned as a committee that we not tax the capacity of not-for-profits in having to adhere to the requirements of the PIPA Act, knowing that there were a lot of not-for-profits in Alberta. I think there's like 19,000 of them. And probably 8,000 of them operate without full-time staff. So expecting that somehow a volunteer-based organization is going to be able to understand and adhere to all of this can be a bit of a stretch. Nonetheless, as we look at the fact that that very organization, even though it may have no staff, may be collecting personal information about Albertans, would we expect that it will adhere to how it treats that personal information? Bottom line is yes. So the commission, the Privacy Commissioner has also indicated his expectation that the not-for-profits would be brought under PIPA, and his displeasure that they were not. What we really heard, and I had asked specifically that certain not-for-profits would be brought in to speak to the committee. So we had groups like the Chamber of Voluntary Organizations, the community leagues, and a few other groups like that come in. And really what they said to us is, either way, just make it consistent. Because right now it's really hard for us to know whether we're in or whether we're out and to figure that out. And again, we're just trying to provide our service. We're just trying to put on, yoga for kids and skating for adults, and that we're trying to do our activity, not worry about all these other things. So just be clear. Either tell us we're in, we're consistently in, or tell us we're out and we're all out. But this, while you're in, if you engage in this kind of activity but not in that kind of activity, is frankly really confusing. So the committee in the end, and we wrestled with this a lot, we had recommended that they all be brought in, just to provide that greater clarity and consistency. And we, in recognizing that capacity issue, we had recommended that there be a phase-in of this, and that there may be, and that there should be some monetary assistance available to organizations to ease their way into that compliance. And maybe that's the reason why the government decided not to include it, is they weren't interested in offering the financial assistance to build the capacity in these organizations to do this. But as a result, we have maintained an inconsistent application to the not-for-profits. We have maintained a confusion for them on how they are supposed to be behaving. And we've left a lot of employees and volunteers and other Albertans that have an interaction with those organizations, also with their personal information and the protection of it, not covered under this legislation. So I think that continues to be an issue, and I think it's something that we need to hear from the government as to why that choice was made in a more thorough way than what we've heard thus far. So I look forward to the sponsor being able to